morning.
Good morning.
All right, we're ready to go?
Yes, Your Honor.
All right, let's go.
May it please the court, Your Honor, Melissa Giassi with Giassi Law here on behalf of the appellant. My presentation will probably be rather short today, but I'll just reserve 2 minutes for rebuttal.
You got it.
Your Honors, there's a very narrow issue in front of the court today, and it stems from whether or not the trial court abused its discretion in denying a motion that was brought under 1.540 after, in my opinion, the record reflects that there was excusable neglect for not timely filing an amended complaint. Just a bit of background. Originally, there were 2 lawsuits filed by my client against Security First. There was a motion to consolidate filed by Security First in the first filed case, and a motion to stay the second filed case. And proposed orders were submitted to 2 different judges in Hillsborough County pursuant to an administrative order. And that was done in November of 2017. I think approximately 5 months later, in May of 2018, in the lower filed case, Judge Cook entered an order consolidating the case and adding the requirement that an amended complaint needed to be filed within 10 days. Otherwise, the case would be dismissed. And as outlined in the affidavit that was filed by the paralegal for trial counsel, that deadline was not calendared, and inadvertently, due to a clerical error, the motion to consolidate did not request the relief that an amended complaint be filed, and therefore the 10-day deadline was not met. However, 4 days later, trial counsel filed an amended complaint. Unfortunately, that was 1 hour after the court had entered an order dismissing the case for failure to comply with the order requiring the amended complaint. The parties proceeded to a hearing on the motion to vacate, which again was supported by the affidavit from Mr. Grajales, who's the lead paralegal, and that outlined the breakdown in the process that resulted in the lack of calendaring of the deadline for the amended complaint. And again, the amended complaint was filed just 4 days late, but unfortunately, again, an hour after the deadline imposed by the order entered by Judge Cook. I think that the affidavit filed by Mr. Grajales established excusable neglect. It explained that there was never a hearing held on the motion to consolidate. The relief requested in the motion to consolidate did not request an amended complaint be filed, and therefore it was clerical error for not bringing it to the attention of an attorney and or getting the deadline calendared. But again, the affidavit also details that upon receipt of the notice of noncompliance, they sprung into action and got the amended complaint timely filed.
Well, let me just address that, because this is an interesting case, because you have 2 lawsuits against the same insurer by the same insured for damages for dates of loss, which were within about 3 weeks apart. In 2016, damage in the kitchen and then damage in the bathroom, and you decide to file 2 different lawsuits. So I don't think that you can honestly argue that consolidation was a surprise. And also, your firm received the motion to stay, and where the defense referred to a motion to consolidate, and your firm did nothing in response, but yet in the affidavit you say you were surprised by that. So the motion to vacate then says, given the circumstances, plaintiff's counsel did not expect the consolidation order to be entered, which contradicts the fact that you're surprised, because you looked at the order and you knew about it and you didn't expect it to be entered without a hearing, but yet you didn't move for a hearing. So the affidavit from the paralegal, and I'm always really, really concerned about law firms that blame staff first, is you were served on both of your emails, and Jonathan Drake was served with this order that clearly said you had to do an amended complaint, and if you didn't, within a window of time, it'd be dismissed with prejudice, correct?
Trial counsel was, Your Honor, to the extent
correct.
you're referring to
Am I correct?
Cayman. You are correct.
Am I correct?
Absolutely.
And it's true
correct.
Your firm did nothing after receiving that, knowing full well you could do a motion for hearing, motion for rehearing, motion for clarification. That was not done.
Correct. Trial
And
counsel,
and
correct.
this attorney that filed this motion to vacate did not make any of those arguments other than blaming his paralegal, who had two different email addresses, pleadings here and something here, and he misplaced it. Correct?
Correct. There was not an affidavit from trial counsel. That's correct.
Well, what's interesting too is this paralegal gives an unqualified legal opinion concerning legal procedure by saying, this was an unusual, extremely rare and unexpected and unusual procedure that we didn't expect to happen, which we didn't expect this order to be granted without a hearing. Well, that leads me to believe that they read the order, they understood the ramifications of the order, and then they just filed it and they let it go, as opposed to, wait, I never knew about this because the whole thing was misfiled and missing. And it wasn't until I got the order of dismissal that I realized that the order of consolidation said I would be dismissed. So help me out. Is this really a surprise? Or this just go ahead.
Going back to, no, thank you. Going back to some of the statements Your Honor made, the surprise, I think, flowed from the fact that the motion to consolidate simply asked for the first filed case, or for the second filed case, to be consolidated.
I agree with
into
you
the
there.
second filed case.
Absolutely agree with
There
you.
was
But
there was no request for an amended
the order that you're
complaint.
complaining about, the order that you're complaining about, you had 7 months to challenge. You even
Correct,
had,
but
go ahead.
I'm sorry. No, the order that was the excusable neglect flows from was the fact that the order granting the motion to consolidate added the requirement for the amended complaint to be filed, and added the fact that if that amended complaint was not filed within 10 days, the ultimate sanction of dismissal would be filed. So I think, to the extent you're looking at the paralegal's affidavit, the surprise flows from the fact that that was not relief that was requested in the original motion to consolidate. So the surprise, being that, there had been a notice of related case filed, there had been no relief, certainly on behalf of the plaintiff, to file an amended complaint, and there had been no question, no relief on the part of the defendant to ask for an amended complaint. They simply wanted the matters consolidated. So that portion of the affidavit to me goes to explain the failure to calendar the 10-day deadline that was imposed in that order.
How about the fact that you properly received through the email portal a notice of plaintiff's failure to comply and did nothing for 3 or 4 days?
Actually, Your Honor, the notice of failure to comply, it's my understanding of the record that the amended complaint was filed within an hour of that notice of failure to comply. It was filed on the same day.
No, you said the amended complaint was filed May 31st, 4 days after the defense served the notice of failure to comply. You had 4 days.
I apologize. You're correct.
And you
correct. I agree.
That. And your firm received that.
Trial counsel, yes, Your Honor. I understand, but again,
so is that a second surprise or a second mistake or a second foible?
Well, the order that was supposed to be complied with, the miscalendaring had already happened. So to the extent, we're not seeking relief from a notice of non-compliance. I think the focus of the motion that was brought was to explain to the court why the original 10-day deadline was not calendared and why it was not met. And certainly, to also point out that, upon receipt of the notice of non-compliance, the amended complaint was filed. So, I mean,
yeah, 4 days
excusable
later.
Neglect from
4 days later, when you can file anything through the portal for 24 hours a day.
I understand, Your Honor.
So you were being accused of violating an order that you claim you never saw. And you waited 4 days to do something about it?
That's the record before the court. Yes.
Okay.
The
right.
paralegal's affidavit outlines the reason that the deadline for the amended complaint was not calendared. The amended complaint was filed 4 days after receipt of the notice, or 4 days late. I do think I need to correct myself. The 14 days after, so the deadline that was imposed by the order gave trial counsel 10 days to file the amended complaint. The notice of non-compliance was filed on the 14th day after the deadline had been missed, and the amended complaint was filed on that 14th day. So no, Your Honor, they did not wait 4 days after receiving the notice of non-compliance. Does that clear up the confusion?
I have in the record that the notice of failure to comply was sent to you and served on you May 27th, 2018. That's
Okay.
the day of the deadline.
Okay, and so at this point, Your Honors, I think that the affidavit that was presented by Mr. Grajales outlines the excusable neglect for not timely filing the amended complaint. The amended complaint was filed, within a reasonable time and with due diligence, and we're asking the court to vacate the order denying the motion for dismissal. And unless there's any other questions from the panel, I'll rest on the briefs that were filed.
All right, I'll save you 2 minutes that you wanted. Mr. Tinker?
Thank you, Your Honor.
May it please the court. Good morning, Mark Tinker on behalf of Security First Insurance Company. I will hopefully also be brief. I just have 2 points that I'd like to make. And first, Judge Sleet, this has to do with a lot of your questioning of Mr. Yasi. And you were asking about when things were received and as far as having notice of the motion and the dates of things. And I just think it's even more than that, is that to the extent that they're claiming surprise or that they did not know, did not anticipate what this order was going to say, the motion to consolidate was filed on November 6th. And then 2 weeks later, on November 21st, following the 13th Circuit's administrative provisions, an email was sent to the judge asking the judge to consider it without a hearing and enter the order along with the proposed order. So the actual literal order that was entered was emailed and copied to trial counsel saying, here's the order that we asked you to enter, Judge. That sat there for 6 months before Judge Cook entered it. So they knew exactly what was being proposed to be entered 6 months before the judge signed it.
So
I
the
think that
proposed order included the language that they are required to file an amended complaint, and also, if not done within 10 or 12 days, it would be dismissed with prejudice.
correct.
All right.
The judge signed the exact order that was emailed and copied to counsel on November 21st, and that is in the record on page 143 of the initial brief appendix. So I think that's the first issue, is I think basically addresses all of those points as far as neglect or surprise is concerned. The second issue is that I think a lot of the arguments kind of commingle what it is that we're here to talk about today, as far as talking about Judge Cook and dismissing the case and what happened with the dismissal. This isn't an appeal of that dismissal. This is an appeal of the order denying a 1.540 motion to set aside the judgment. And the judgment, the actual order of dismissal, Mr. Grajales, his affidavit admits that he had that the very morning after it was signed. He even puts the time, 9:05 a.m. on day one, he had that in his possession. It is a 1-paragraph order of dismissal with prejudice, right in the style of it. There's no mistaking what that is. Nothing was happened with that. No motion for rehearing was filed. No appeal was filed. Nothing occurred for 7 months. And the case law from the Supreme Court is very clear that 1.540 is not a substitute for rehearing, new trial, or appeal. if those remedies are available, you have to take them. Mr. Grajales admitted, I had this on day one at 9:05 a.m. and nobody did anything. So I believe that forecloses 1.540 relief. At the very least, it demonstrates that Judge Cook did not abuse her discretion in denying the motion. So that's really all that I have to say. Unless the court has any other questions, I'll yield my time. Thank you.
Is there a rebuttal?
Just briefly on the issue of rehearing, we recognize that there were many other issues that could have been raised on a rehearing or a direct appeal. The relief that was sought here is the relief that is certainly available under 1.540, and the court certainly has jurisdiction to consider it. Maybe through a rehearing and a direct appeal, we could have argued that this was too harsh of a sanction. Maybe we could have argued against, the consolidation and the appropriateness of that to begin with. But, the court does retain the limited jurisdiction to grant relief from orders where excusable neglect has been demonstrated. And
Well, I
again,
don't
the
think
excusable neglect.
counsel is arguing that. I don't think counsel is arguing that the trial court lacked jurisdiction. I think he's saying that the trial court didn't abuse its discretion. It's a different issue.
Yes, Your Honor. Well, but he also said that the fact that the paralegal acknowledges that the order was in his hands at the time where a rehearing or a direct appeal could be brought forecloses the right of the plaintiff to bring this motion. And that's argued in the briefs as well. So that was the specific point that I was trying to address. So I understand that his second position is also that the trial court did not abuse her discretion. But that was just a final point that I wanted to make on rebuttal. So thank you for the court's time today.
All right, thank you. That concludes that case. We're going to move on to the next case, which is Zenith Insurance versus Pearson Muller.